Yes, Mr. Jafferty.
Thank you. My Lord, looking at the time, we have 2 hours left and 3 issues left to cover. I think I'll move on to the judgment.
Yes.
In Hock, we have 3 judgments to cover: Hock, Munib Asif and Adil Afzal, and 3 issues to consider, plus the policy guidance. So I will come back to the temporary admission point at the when it becomes relevant.
Yes, we'll try to not ask you more questions than we can help. We've got a lot to get through in.
My Lord, yes, the written case obviously makes the point. I'm going to expand upon it, but I'll hopefully keep to my time limits of 2 hours. 1112 is the Hock judgment in the bundle. And my Lords will see that the construction of paragraph 276B was an issue of law, of principle, that the court had identified at paragraph 3 of the judgment. And my Lords will also see, and I'll just give you the reference, 616 of the bundle, that Lord Justice Dingemans had ordered these appeals to be linked in order to give guidance on the construction of 276B. At paragraph 11, Lord Justice Underhill sets out the definition of lawful residence, which here includes all 3 elements of the definition in the immigration rules. At paragraph 14, he sets out Rule 39E. And at paragraph 15, the appellant submits that in the first sentence, he correctly identifies what 276B5 is doing, disregarding the fact that an applicant is an overstayer. And that is crucial because that is, in our submission, one of the key distinctions between the reasoning in Hock and Munib Asif and the reasoning in Afzal. What is being disregarded? In Afzal, the court proceeds on the basis that it is the period of time that is being ignored. In Hock and Munib Asif, the court proceeds on the basis that it is the fact of overstaying, the quality of that, of leave during that period of time, that is being ignored. And that is consistent with the way in which paragraph 276B5 has evolved over time. And Lord Justice Underhill goes through that, but just going through the judgment, the facts are set out at paragraphs 16 to 19. All of these were open-ended overstaying cases, so different on the facts from the instant appeals. That's confirmed at paragraph 20. And the analysis of the construction begins at paragraph 29. At paragraph 30, he describes the effect of subparagraph 5 as seriously problematic, and my Lords will perhaps have seen already that what he does is break down 276B5 into 3 elements: element A, element B, element C. Would it be helpful to go through those elements? Are my Lords familiar with it?
I think it might be helpful. Yes.
I'm grateful, my Lord. Let me take my Lords to the actual rule. It's at page 773. And subparagraph 5 begins on the next page, 774. And Lord Justice Underhill broke it down in 3 elements. Element A being the primary requirement of the subparagraph. The applicant must not be in the UK in breach of immigration laws. And he held that that was a current requirement at the time of the application and the time of the decision. And then element B is the exception to that. And that exception is where paragraph 39E of these rules applies, any current period of overstaying will be disregarded. And so it's the breach of immigration laws that is the problem. Breach of immigration laws includes more than just overstaying. It also includes breaching the conditions of your leave. So you might not be an overstayer, but might be in breach of immigration laws because you're working in excess of what you're permitted to work, or some other restriction on your leave, for example, a restriction on claiming public funds has been breached. So it's only the overstaying that is accepted, and it is clear that element B is therefore concerned with the fact of overstaying, not with a period of time. The period of time is irrelevant. And then you have element C, which Lord Justice Underhill found was in the wrong place, because it has no logical connection with the primary requirement in subparagraph 5, which is not to be in breach of immigration laws at the time of decision. And element C is that any previous period of overstaying between periods of leave will also be disregarded, where the previous application was made before November 16 and within 28 days of the expiry of leave, or the further application was made on or after the 24th of November 2016 and paragraph 39E of these rules applied. It's not in dispute that the appellant Afzal comes within element C. The dispute is, what is the effect of that? The appellant submits that disregarding means that you overlook the fact of overstaying so that you count the period of leave as lawful residence. The Court of Appeal in Hock reached the same conclusion. The Court of Appeal in Afzal reached the conclusion that disregarding means that you just ignore the period entirely, so that it acts as a shield, not a sword, in the phraseology used by the court. It doesn't break your lawful residence, the continuity of your lawful residence, but it doesn't add to it. It's just ignored.
But the 10 years has to be, you have to qualify for that by the date of your application, do you?
My Lord, it's by the date of decision. So you can make an early application,
right.
But you should have the 10 years lawful residence at the date of decision. So if you have, and this was the case in Hock, I think all of the appellants there were within a few months of 10 years lawful residence, but their leave expired because their period had been acquired by virtue of Section 3C. And so when their appeal rights were exhausted, the lawful leave came to an end. They made a further application within 39E before the 10-year period had been acquired or accrued. By the time of the decision, they had reached the 10-year threshold, but the question was, in disregarding the current period of overstaying, do you count that as lawful residence? And the answer was, no, you don't, because subparagraph 5 elements A and B have no connection with the calculation of 10 years lawful residence. But Lord Justice Underhill found that the third element, element C, was in the wrong place. It shouldn't have been in subparagraph 5 at all. It should have been an addendum to subparagraph 1A. And it impacted upon the 10 years calculation, and therefore when calculating 10 years, a bookended period within 276b5 is disregarded. What is in dispute now is whether, when you disregard, you ignore the overstaying or you ignore the period of time. In Hock and Munib Asif, the courts found that you ignore the overstaying so that the period of time is counted. And in Afzal, the court found that you ignore the period of time so that you don't count that period at all. So in the instant appeal, that would mean that the period of 19 months that it took for the Secretary of State to decide the application is not counted, but it doesn't operate to break the continuous lawful residence either. It's just ignored as if it never happened. And one takes lawful leave as the period accrued up until leave expired and then starts adding on again at the point where leave was granted in 2019. The appellant's case is that that is wrong. Disregarding means that you disregard the fact of overstaying and you count that period as if the appellant had lawful leave. And that's where the temporary admission example becomes relevant, because the appellant says that that approach is consistent with the way in which temporary admission is treated, because temporary admission is not lawful leave, but if you have temporary admission and then you're granted leave, that whole period becomes lawful. And so the way in which disregarding overstaying, bookended overstaying, is treated in Hock and in Munib Asif is consistent with the existing policy of the rules in the way that it operates with respect to immigration bail and temporary admission.
But if you have temporary leave, you're not in the UK in breach of immigration laws.
I think you're not in breach of immigration laws, my lord. That's right. But the point is the policy in relation to what counts as lawful leave. So it's not relevant to 276b5, but then it's accepted now that element C is in any event not relevant to 276b5. It's relevant to the calculation of lawful residence. That's what Lord Justice Underhill found. Lord Justice Dingemans agreed. Lord Justice McComb agreed. It wasn't in dispute in Afzal, and my understanding is that the Secretary of State accepts that as well, that element of the rule is actually directed at calculating the 10-year period, as opposed to what 276b5 is actually about, which is current breach of immigration laws.
And why doesn't little 5, if that's right, say, instead of will be disregarded, will be treated as lawful residence? Because that is in effect what happens with the temporary admission provisions, which is what we were doing.
My lord, yes, and it would have made everyone's life much easier had it said something like that or something else. And I'll come on to the other parts of the rules that we rely on, and the guidance. The difficulty is the lack of clarity. And the difficulty is the way in which the rules have been drafted. And my lords will note the criticisms across the board in Hock of the way the rules were drafted, the criticism repeated by Lord Justice Dingemans in Iyieke in relation to this, and that does present a difficulty. And therefore there is no clear outcome. And that is why the appellant's case is that there is ambiguity in the rules, because they're drafted in a manner that leaves a lot to be desired. But when one looks at everything in the context of the rules, in the context of the way in which another rule treats a situation whereby you are clearly not counting a period of leave, and contrasts it with this, when one looks at the way the word disregard is used when it's first introduced into the rule with respect to current breach of immigration laws, what is clear is that what is being ignored is the overstaying, not the period of time. And that is where we say Hock got it right, that what is being disregarded is the fact of overstaying, and that is where we say Afzal went wrong, one of the ways that Afzal went wrong, because it considered that what was being disregarded was the period of time. But if one just looks at elements A and B, and the original version of the rules only had elements A and B, that's when the word disregard was first introduced into this part of the rules. It only makes sense if one is disregarding the fact of overstaying, because the period of time has no bearing on breach of immigration laws.
Well, the argument against you is that the first sentence in 5, elements A and B, as you've called them, are directed towards the legal status of the applicant's presence in the UK. And in that context, a disregard of any current period of overstaying is a disregard of the fact that he's in the UK in breach of immigration laws, because that's what this is concerned with. But when you come to C, if it's right to say that that's directed to the calculation of a 10-year period, then it's not simply the relevant point isn't simply whether you are in the UK lawfully or not. It's to do with the calculation of a 10-year period, and it's a matter. It's open for argument whether what the effect of a disregard. The effect of a disregard is that you ignore the period of unlawful presence, or you deem it to be a period of lawful presence.
But my Lord, if one goes to the original, and I think this is set out in the statement of case, which might be the easiest place to go to, because it all follows in sequence there. I'll just find the relevant paragraph. If I could take my Lords to 668 of the bundle. And my Lords will see on the next page, 52, paragraph 52, the first version of 276b5, and it only contains what Lord Underhill has described as elements A and B. So the applicant must not be in the UK in breach of immigration laws, except that any period of overstaying for a period of 28 days or less will be disregarded. So what is being disregarded is clearly the fact of overstaying. And if one is to give consistent meaning to the word disregard in the rule, you ignore the overstaying. The terminology used in both elements is the same. We then, as the statement of case unfolds, take my Lords to the rule as it develops.
But the purpose for which is, disregard has to take its, the effect of the word disregard must depend on the context in which something is being disregarded. And if it's being disregarded in assessing whether the applicant is in the UK in breach of immigration laws, then what is being disregarded is the fact that he is in the UK in breach of immigration laws.
Yes.
If the context is the calculation of a 10-year period, then it doesn't necessarily follow that the word disregard has the same effect.
My Lord, I accept that. That is a possible way of looking at it. The reason I'm focusing on the way in which the disregard must be construed for elements A and B is because the Court of Appeal's reasoning was that it must have the same effect, the same meaning. And therefore, if the meaning of the initial introduction of disregard in elements A and B is to ignore the overstaying, it would be, per the Court of Appeal's reasoning, odd that in the same rule you have the same word placed by the rule in the same subparagraph doing two different things. So on the one hand,
Sorry, if I may say so, I rather took the force of my Lord's question to be that you give the word disregard the same meaning, but that leaves open what are you disregarding. It's clear in elements A and B what you are disregarding.
yes.
It doesn't follow that in element C it's the same thing that you're disregarding, because what you're disregarding depends upon the purpose and context that the rule, the particular rule which is being disregarded, has.
And my Lord, I say that is one way of looking at it. My point is that if one is examining the Court of Appeal's judgment, its reasoning is that we give the same meaning to disregard, and it must disregard the same thing. So in the Court of Appeal's judgment, it considers that the first element is disregarding a period of overstaying, and the second element is also disregarding a period of overstaying, meaning that you ignore the period. The appellant's point is that you're disregarding the fact of overstaying in both. Now,
Which paragraph, sorry, just to help me,
yes.
which paragraph are you now referring to in the Court of Appeal?
We've not gone to it yet, but I'll take my Lords to the paragraph. It's paragraph 55, I think, is the relevant.
Thank you.
At 83.
Yes, thank you.
And if one is looking at 1A, of the rule, what 1A requires is 10 years continuous lawful residence. So if one is qualifying the requirement in 276B1A, one is qualifying one of those elements. The number of years, the continuity of residence, and the quality of residence. And in my submission, when one is disregarding overstaying, one is clearly looking at the quality of residence. And if one disregards the quality of that residence as being a period of overstaying and ignores that, then one is left with a period of time that is counted as lawful residence. And my Lords, to better understand why the appellant says that this is consistent with the way that the long residence policy has always operated, I go back to the policy, the concession that I referred to this morning, which clearly said that where there are gaps, you count those gaps as an exception. I go back to the temporary admission situation whereby the rule itself treats temporary admission, which is not lawful leave, except under 276B, as lawful residence if leave is eventually granted. And therefore, what would be happening here if the disregard meant that you discount the quality of the residence and count the period would be consistent with what the rule has always done in relation to the exercise of discretion. I'm sorry, the policy did in relation to the exercise of discretion, and what the rule has always done with respect to temporary admission. It's not something different or unusual. It's not a rewriting of the policy. It's simply an extension of the policy to take account of the overstaying provisions that were brought in after 2012. And my Lords, if I could just take my Lords to, and I'll just refer my Lords to the relevant parts of Lord Justice Underhill's judgment. The reasoning begins at paragraph 29, The reasoning with respect to...
Page, please, sorry.
I'm sorry, my lord. It's 1119.
Thank you.
The reasoning in relation to element A is at paragraphs 30 to 32. The reasoning in relation to element B is at paragraph 33. At 34, you then see the start of the reasoning with respect to element C, which is the particularly problematic part of the rule. The drafting history is considered at paragraphs 36 to 37. Paragraph 38, consideration is given to the policy guidance, the Secretary of State's policy guidance. And in the last two sentences of that paragraph, you'll see that Lord Justice Underhill considers that the Home Office itself thought that element C qualified subparagraph 1A, and the court was told that the terms of the guidance reflect the approach which the Home Office takes in practice. And then at 39, he considers that, exceptionally pursuant to the decision in Pochreal, the rule is ambiguous and therefore reliance on the guidance is permissible. But he concludes that paragraph by saying that it isn't necessary, it's not essential to his conclusion to rely upon the terms of the guidance. Paragraph.
Forgive my asking a question that may make a sort of Bateman cartoon reaction. Could a previous period of overstaying render somebody currently in breach of immigration rules?
My Lord, that was considered by the Court of Appeal and a reason for finding that element C is in the wrong place, because it could not possibly be that element A, which is concerned with current overstaying, could be impacted by a previous breach of immigration law.
Well, you say element A is concerned with current overstaying.
Current breach.
Yes, current breach, and I just wondered whether the fact that somebody might, for example, have been in the UK as an overstayer, working unlawfully, and so forth, might be a current breach or continuing breach of immigration law.
The reasoning in Hock was that the use of the present tense must not be in breach of immigration laws was clearly directed towards a current situation, that a previous situation could not possibly impact upon that requirement and element in subparagraph 5.
I'm not sure you're really answering my question.
My submission is that if that is the requirement, that you must not be in breach, a previous breach cannot render you currently in breach. I am not aware of any part of the sort of requirements of immigration control that would mean that a historic completed breach can have an impact on whether you are currently in breach. If there is an ongoing breach, of course, you would still be in breach. But if, for example, as my Lord said, in the past, you had worked beyond the hours permitted, let's say, for a period of 2 years.
But I suppose you would say, you'd point out to me that the element A is directed to whether you must not be in the UK. So it's your current presence in the UK. So if you currently have leave to be in the UK, then you can't be in the UK in breach of immigration laws, I suppose.
My Lord, yes, but as Lord Justice Dingemans points out, being in breach of immigration laws, as it's defined in the immigration laws, isn't confined to being lawfully here.
No, but it doesn't.
Conditions.
No, I'm wondering if the answer to my own question may be that A doesn't say the applicant must not be in breach of immigration laws. It says the applicant must not be in the UK in breach of immigration laws. So it is specifically your presence in the UK which is the focus.
Yes, and the breach. But in any event, my Lord, my answer to my Lord's question, I think, would be that a past breach that has been completed, therefore it's not ongoing, cannot result in an applicant being in breach of immigration laws. It would be a historic breach, which might have an impact on eligibility, because there is discretion to refuse, both built into 276B and on general grounds. So if the breach is particularly serious, even if one meets all the requirements of legality, continuous residence, and not being in breach, a sufficiently serious historic breach might still result in the application being refused. So there is a considerable fail-safe mechanism built into the rules, both 276B and generally, to ensure that any sufficiently serious conduct doesn't benefit an applicant, or an applicant cannot benefit from ILR if there has been sufficiently serious conduct.
Yeah.
And my Lords, then at paragraph 50, Lord Justice Underhill considers a submission.
Sorry, just before you move on, can I just check? Paragraph 276B1A, 10 years continuous lawful residence. Does that include issues of working without permission or having recourse to public funds if there's a condition saying you can't?
That particular requirement, my Lord, no.
So that's just looking at permission physically to be in the UK, is that right?
It's looking at length of residence and the continuity. You don't have to be physically present, because the continuous residence allows for absences of up to 18 months. But it's just looking at the period of time
for which you had a visa entry.
Yes.
So it doesn't. That's not looking at
any breaches, any conduct issues.
All right.
But the conduct issues come into 276B 2 and 3.
I must say, my initial reaction is one of scepticism as to whether the drafting could be quite so cack-handed as to put into 5 something that's meant to be in 1. You took us through the earlier versions of this in the IDIs, and And there, the requirement was to be satisfied that the applicant has acted lawfully throughout the entire period and has made every attempt to comply with the immigration rules, as that was put in the 1307. Now, that means that if you were applying that, you would be looking at the entire history of the person's presence in the UK and whether they had complied with immigration law throughout.
My Lord, yes, but that element of the guidance was in relation to exercise of discretion. So if one is considering exercising discretion because there has been a failure to meet the lawful residence requirement, that's the guiding principle. That's not a guiding principle overall, because the rules are the rules. You meet the rules, you get your ILR. But if you don't meet the rules and one is considering an exercise of discretion, that is the quality one is looking at from an applicant.
Yeah.
But in any event, 276B 2 and 3 are clearly directed towards conduct that would mean that the grant of indefinite leave would not be appropriate.
Yeah, I mean, really, I'm wondering, put it this way, whether 5 should really be read as if it said the applicant must not be or have been in the UK in breach of immigration laws, and then you disregard any current period of overstaying under 39E, and you can disregard previous periods of overstaying provided A or B is satisfied.
My Lord, fortunately for me, that point was conceded.
Right. So well, if the Secretary of State isn't taking the point, then I suppose that's that.
And I'll take my Lord to the reasoning why it was conceded.
I'm so sorry to just ask again about 276B1A. Is that common ground that lawful residence doesn't refer to situations where there's a breach of a condition attached to the visa, or is there some authority that says that?
My Lord, I think it is common ground. It's not something that I don't think it's previously come up in any of the cases as to whether lawful residence includes that. But if one looks at 276A, which defines lawful residence, one can see that and I think it was said in Afzal, that the definition is exhaustive per a previous Court of Appeal decision in MD Jamaica. My Lord, if you're looking for the relevant part, it's 771, which is the lawful residence section of 276A, and you can see that the term is defined, and therefore it doesn't look at a person's conduct during that period, but conduct can, of course, come into the consideration when one moves on to 276B 2 and 3. So, my Lord, will see that at 276B2 on 773, having regard to the public interest, there are no reasons why it would be undesirable for him to be given indefinite leave to remain on the ground of long residence, taking into account his, and C, personal history, including character, conduct, associations, and employment record. And then 3, the applicant does not fall for refusal under the general grounds for refusal. So, past misconduct is not something that is relevant to the other elements of the rule, but it might become relevant to 276B 2 and 3.
Yes, thank you.
And we were at 1122, the judgment in Hock. Just.
And your basic submission is going to be all this is correct. You're going to say Lord Justice Underhill was spot on, are you?
That's right. Lord Justice Underhill was spot on. Lord Justice Dingemans was spot on. Lord Justice McComb was spot on this element. And Upper Tribunal Judge Blum was spot on. And the Tribunal Reporting Committee was spot on when it reported Upper Tribunal Judge Blum's determination.
And just to go back to a point that was just being raised, it is now it's common ground between the parties that we do have to read the B and C parts as qualifying the earlier section, subsection 1.
My Lord,
That's
yes.
not in dispute.
That's not in dispute. So, my Lord will see that that was conceded. If one looks at paragraph 38 of the judgment, the penultimate sentence, clearly the Home Office itself thought that element C qualified subparagraph 1A. Then Ms Giovanetti told us that the terms of the guidance, as one would expect, reflect the approach.
I'm so sorry, which paragraph are you in?
38
Of
HOC, 1122.
on page
1122, apologies.
1122.
Yes.
I actually meant in this case.
I don't understand that
No.
concession has been withdrawn. I mean, that's the basis upon which Afzal was decided.
Thank you.
And my Lord, that is, I think, confirmed and set out at paragraph 59 of Lord Justice Underhill's judgment.
When you said before that you can draw on other aspects of immigration law to support this approach that one counts the period, would your submission go as far as to say that the approach taken by Sir Patrick Elias would be unique in this area? That in other words, not counting the period would actually be so unusual as to be unique? Or are there other examples within immigration law that of this occurring?
I would make that submission, my Lord, with respect to the Section 3C issue. I wouldn't make it with respect to this issue. The reason being that there is expressly a provision in the rules where a period is not counted. But what is pertinent, and I'll take my Lords to it, is that the word used is different. The word discounting is used as opposed to disregarding, and the guidance is crystal clear on it, so that a caseworker knows exactly what's going on.
Thank you.
And my Lord, just in relation to the element C issue, it's paragraph 42 where Lord Justice Underhill sets out that the matter was conceded.
I'm so sorry, did you say 39 or 49? 42.
42. My Lord, then at paragraph 50, Lord Justice Underhill considers a submission made on behalf of one of the appellants that if the paragraph 39E disregard was not available for open-ended periods of overstaying, that would be irrational or a disproportionate interference with an applicant's Article 8 rights.
So, which paragraph are you reading from?
Paragraph 50, my Lord.
Thank you.
And it is in that paragraph that Lord Justice Underhill is crystal clear in that he considered that the period would be counted when one disregards it. It's about halfway down the paragraph. It is in those circumstances unsurprising that the Secretary of State should think it right to allow the period between the expiry of the previous leave and the grant of the further leave to count as continuous lawful residence. And that is accepted by the court in Afzal, that was what the court in Hock concluded, and that is also the basis upon which the upper tribunal gave its judgment in Munib Asif. If I could then take my lords to 1129, which is a part of Lord Justice McComb's judgment. In paragraph 76, and although Lord Justice McComb disagreed with the majority on this issue, they were all in agreement. In my judgment, for the purposes of paragraph 276b, if one is not present in breach of immigration laws because the period since expiry of leave is disregarded and therefore to be treated as present with leave, it is odd to say that nonetheless one is not present lawfully in the UK for the purposes of calculating the 10-year period.
He has a cross-reference to paragraph 6.
That's of the immigration rules, so that's the definition of breach of immigration laws and overstaying.
Do we have paragraph 6?
My lord, yes, we do. It is at 749.
Thank you very much.
I'm so sorry, that doesn't seem to be the right reference.
I think it's overstaying, yes. There's a definition of overstaying there, and that is
So that's not paragraph 6, though.
it's the paragraph 6 is all of the definitions, my lord, if I'm not mistaken.
Well, maybe we've only got maybe we haven't got the whole of the document.
It's a very long section. I will.
We have at the bottom of 749 we have paragraph 4, and then page 750 we seem to be in the middle of an interpretation provision.
Yes, if one looks at the document page numbers on the bottom right-hand side, we can see we haven't got everything.
Yes, my lord. I will. If my lords look at the index to the document, you can see that it's described as para 6 of the immigration rules.
Right.
Definition of overstayed or overstaying.
Okay.
My lords, we will get the full version.
Anyway, this is the cross-reference, you say, but it would be helpful.
Yes, my lord.
Document.
And my lords, at paragraphs 85 to 86, again in Lord Justice McComb's judgment, there is a useful consideration of another provision of the rules where the term disregard has been used. And it is clear that those periods are to count. That is what the Court of Appeal in Masoom Ahmed used to distinguish between 276B and that rule. And my lords will see then also at paragraphs 91 to 92, Lord Justice McComb considered that the policy guidance also treated disregarded periods as counting towards the 10-year period. my lords, then Lord Justice Dingham's judgment.
And I'm so sorry, the cross-reference there is to where in our bundles? The one version, the example of the version published to the Home Office staff on the 3rd of April 2017.
Which was 748. I believe, my lord, that the April 2017 version is 748.
All right, thank you.
And then, my lords, Lord Justice Underhill's judgment at 104. This is at 1134 of the bundle. Sorry, Dingham's. Lord Justice Dingham's judgment. He agrees with Lord Justice Underhill and gives his reasons in that paragraph. 3 reasons. First, because it accords with the explanatory memorandum, which was the cause of the Secretary of State's consideration of that explanatory memorandum.
And do we have that in our bundle?
My lord, yes, it is in the bundle. Can you tell me where it is?
If at some point we could be given.
I'm grateful, my lord. And it also reflects the Secretary of State's practice when dealing with applications, and that is what the court considered that it had been told. He also considered that that rule was ambiguous, and therefore, per Poch Real, it was permissible to take into account the Secretary of State's policy. And then you have the second and third reasons which don't impact upon the issues in this case. And my lords, just for reference, paragraphs 59, 96 and 105 of the judgment in Hock set out the concerns that all 3 Lord Justices had about the way in which the rule had been drafted. And that is, we say, relevant to construing it, because if there are concerns about the thought that has gone into it and the way that this has been drafted and the piecemeal approach to it, one has to look for meaning by reference to the entire context rather than just construing it akin to a statute, which in any event is not the proper approach. My lords, the explanatory memorandum is at 856.
Thank you very much.
If I could then take my lords to the judgment of the upper tribunal in Munib Asif. It's at 1212. Which does a much better job than I have done of taking one through the judgment in Hock. And if I could give my lords the references, my lords will see the way in which an experienced judge of the upper tribunal has construed the judgment in Hock, but has also independently construed the policy guidance. And so my lords will see the head note at 1212, which is very clear in terms of what the tribunal found the law was pursuant to the decision in Hock, and in accordance with its own additional reasoning. At paragraph 2, my lords will see that the issue that was before the tribunal, precisely the same issue that arises before this court. At paragraph 17, there is a conclusion with respect to the judgment of Lord Justice Underhill. At paragraph 19, he quotes from paragraph 50 of Lord Justice Underhill's judgment and puts in bold the passage that is consistent with his finding. Paragraph 20 notes that Lord Justice Dingemans agreed with Lord Justice Underhill. And at paragraph 21 considers the judgment of Lord Justice McComb. You then have the facts and the decision of the first-tier tribunal. At paragraph 32, you have the submission made on behalf of the appellant. At paragraph 34, you have the submission made on behalf of the respondent. And that submission is identical to the submission advanced before the Court of Appeal and before this court. Paragraph 38, he rejects the respondent's submissions for the reasons following.
This was a so-called bookended case, was it?
That's right, my
Yeah. And Hock was all open-ended.
All open-ended, my lord, which is why Afzal found that it was not binding.
Yeah, yeah.
At paragraph 39, there is reasoning with respect to the conclusion, and that reasoning reflects the submissions made on behalf of the appellant. In particular, what is being disregarded. And he also draws from the judgment of Lord Justice McComb at paragraph 40, although he differed on the outcome for open-ended overstaying, the judge found that his reasoning with respect to what was being disregarded was persuasive. And at paragraph 41, he also finds, consistently with Lord Justices Underhill and McComb, that and Lord Justice Dingemans, in fact, that it was appropriate to look at the policy guidance because this was a case where the rule was ambiguous, and independently he concludes, adopting the same approach, he finds that the respondent's practice, as disclosed in her guidance and the examples contained therein, does treat periods of overstaying that meet the requirements of the second disregard as constituting lawful residence. For the purposes of paragraph 276b1, this constitutes further support for the construction advanced on behalf of the appellant. And then he concludes in relation to the construction. So those two judgments support the appellant's case. And now we have the judgment in the instant appeal, which is at 66.
Just before we turn to it, can I just ask you, look, the definition of continuous residence, we're told, means residence in the UK for an unbroken period.
My lord, yes.
And lawful residence means residence which is continuous residence pursuant to leave. Now, if a period is broken, for example, by absence from the UK, does that means one resets the clock, does it?
My lord, only if that absence is outside of the provisions made in 276AA.
Yes.
So there is provision made for a period of time somebody can be absent.
Yeah, and under those provisions, the period of residence in the UK shall not be considered to have been broken.
Yes.
So if it's a period of absence that doesn't qualify, then does the clock go back to zero?
It would, my lord, yes.
Right.
Because whatever the nature, the quality of the residence, there wouldn't be continuous residence.
Yes.
So, for example, in Roman numeral 5 in 276AA, shall be considered to have been broken if the applicant has spent a total of more than 18 months absent from the UK during the period in question.
Yep.
So if that absence took place early on in the 10-year period, then the clock resets from a relevant point.
Yes. Yeah.
If it takes place later on, then you're in trouble. You've got to start from scratch.
Yes.
But the policy guidance contains discretion to waive absences.
Yeah.
But obviously those are strictly regulated.
And if the period of absence is one which doesn't break the period under 276A, does that mean the period of absence, does that mean the clock is, as it were, stopped and then restarted at the same place when you return to the UK? Or does it mean the period of absence actually counts towards 10 years?
My lord, it counts. And there are examples in the policy guidance, which I will take my lords to. And so this is one of the stark consequences of the rule. And so if one is looking for logic and fairness, one often doesn't get that when one has a rule, because there will always be cases that fall outside the rule where one says, well, what's the logic, what's the fairness in that? Right. If one looks at the facts in Hock, all appellants were in the UK lawfully up until a few months prior to the 10-year period. Yeah. They arrived lawfully, they were pursuing studies and doing other things, contributing to the economy, paying for studies, etc. Yeah. They fell short, and there was hardly any absence. But somebody could have spent 18 months overseas during the 10-year period, so that actually the residence in the UK is only 8.5 years, yeah, and still qualify. And then, of course, you have the temporary admission example, which is particularly stark, because in the example given in the guidance, the person arrived in the UK without leave, was granted temporary admission, was on temporary admission for 8 years, was then granted leave on the basis, one presumes, of circumstances that ensued after he came here without leave, and within 2 years he's entitled to indefinite leave to remain. So that is the way the rule works.
Yes, well, I mean, that's really what I'm trying to understand. And then coming on to periods of overstaying. If you have a period of overstaying which is not disregarded,
Yes.
does that break the period of continuous residence?
My Lord, it would. And again, the policy guidance contains discretion
Yes,
to
subject.
disregard. But if
Under the rules, the effect of not disregarding a period of overstaying is that the period of continuous residence is broken, with the consequence that the clock goes back to zero.
my Lord, the continuity of residence is not broken, but the continuous lawful residence is broken. So the legality is affected.
Yes, well, quite.
Yes. And so one goes. So one could have a situation where you have 9 years of flawless leave, and then after 9 years you don't apply within the 14 days. You might apply within 15 days. You get leave, but there is a break.
Well,
You're back to square one.
let's just think about this. I mean, the concept of breaking continuous residence is specifically to continuous residence, and that's to do with absence from the UK, being in prison, or the like.
Yes.
There isn't
The guidance refers to the
Yes,
situation for lawful residence as
Yes.
gaps in lawful residence.
Yeah. So lawful residence, we know, is defined as, well, it's rather curious, because it's defined as residence which is continuous residence pursuant to leave to enter, etc.
Yes.
But when we come to 276B, you need to have had 10 years continuous lawful residence. So does the period as an if a period of overstaying is not disregarded, how does that affect the
It breaks it, my lord. It breaks it, which is the contrary argument, which is the construction in Afzal, and which is the case put forward by the Secretary of State, that the effect of disregarding is to prevent an overstayer from those consequences of breaking the period.
Okay, thank you.
The clock starting again just depends upon the definition of continuous.
The clock starting again depends on the definition of continuous if it is absence from the UK that is the problem, or the definition of lawful if it is the legality that is the problem. So the clock could start because of an absence from the UK that is out with what is permitted, or the clock could restart because you're in the UK but your legality has been affected. So there's two elements to 1A. Continuity of residence and legality of residence.
And just to be clear, it's legality of residence in the very specific sense of having visa permission to be here.
Or an exemption from immigration control or the temporary admission.
Yeah, but
Definition.
not conditions attached to...
No.
So, I mean, forgive me if I'm wrong, but it's rather looking to me at the moment as though the period of overstaying doesn't affect continuity of residence as
My Lord,
such.
No.
But it goes to the question of the
Legality.
of whether you have continuous lawful residence. Yeah.
And we're not sure that that was something that was properly appreciated by the Court of Appeal in Afzal. We've set that out in the statement of case. I'll come to it if we have time. So, my lords...
I mean, the Court of Appeal in Afzal were right to this extent, weren't they, that it makes a considerable difference whether a period of overstaying breaks continuity, so that you have to start again, or whether
Counts.
it counts, in which case you bring that into account for the 10 years, or there is a possible intermediate position, which is you don't lose all the benefit of the continuous lawful residence you've had up to the period of the overstaying, but if you're covered by little 5, the element C, that doesn't count as a break, so you don't completely lose the benefit of that, but retain it and the clock starts again.
Yes. So, my lords, looking at the reasoning in Afzal, which begins at paragraph 52, which is page 83 of the bundle, Sir Patrick Elias makes 3 preliminary observations which are key to his final conclusion, because he reasons that those observations sit inconsistently with the construction in Hock. So the first is that the definition of lawful residence in 276A is exhaustive. And that is right, but we say that there is a flaw in the reasoning, because there is no focus on Roman numeral 2, the temporary admission definition of lawful residence, because that is, well, we say the disregard resulting in leave counting is a natural extension of that definition. And at paragraph 53, he concludes, but in my view, where an important concept such as the relevant period of long residence is concerned, the variation to the definition in 276A would have to arise either expressly or by necessary implication. We also say that that is an unnecessary gloss on the exercise that the court is concerned with, which is understanding the rules from the entirety of the context and the language, and trying to understand what the Secretary of State intended. That approach is akin to statutory interpretation. The second, at paragraph 55, is that the concepts of being disregarded, periods being disregarded, would be expected to have the same meaning in both contexts. And we say that there are 2 difficulties with this aspect of the reasoning. First, the court misconstrued what was being disregarded, and that's why it considered that Hock reached a construction that resulted in inconsistency. If one considers that the period is being disregarded, then yes, one can see the point, that in one case you're not taking it into account, and in the other case you are taking it into account. But if it's just the quality of that period, so the fact of overstaying that is ignored, you're ignoring it in both contexts. The different effect is a consequence of where that mechanism bites. So in element B, the ignoring results in you satisfying the requirement in subparagraph 5 of not being in breach of immigration laws. But if you apply the same reasoning to 1A, ignoring the fact of overstaying means that you treat that as lawful residence. You're doing the same thing, it's just the effect is different because of where it is placed in the rule.
The requirement under 276 capital A little b Well, the definition there of lawful residence is residence which is continuous residence pursuant to existing leave to enter or remain. We didn't worry about 2 and 3, I think. And the problem, while there's been a period of overstaying, is that, as a matter of fact, there is not continuous residence pursuant to existing leave. You've got distinct periods of, in a book-ended case, you've got distinct periods of residence pursuant to leave, which are discontinuous. And the effect of, as a matter of ordinary English, in that context, the effect of disregarding the period of overstaying would be to render, one might have thought, to render continuous the 2 distinct periods of lawful residence.
Well, look, that is the construction that was reached in Afzal, and that happens if you disregard the period.
Yeah.
So you just ignore the period as if it never happened.
Well, you see, it's disregarding it for the purpose of applying the definition of lawful residence, which looks to continuity pursuant to leave to enter.
Well, my lord, what I would say is that continuity of residence is actually dealt with comprehensively by little a, 276A little a. It is a curious form of drafting that lawful residence means residence which is continuous residence pursuant to when continuous residence has already been defined.
Yes, but whether you're an overstayer or not only affects
The legality.
qualification under B1, doesn't it? Whether your residence is pursuant to leave to enter.
My lord, yes. And what we say is that if you ignore the fact of overstaying, then you're considered to be somebody with existing leave to remain or leave to enter. And we say that temporary admission is also relevant when one is considering whether disregarding so that one counts the period is somehow an aberration of the way in which long residence provisions work. We say that it is helpful to consider that because it shows that the construction adopted in Hock is consistent with a long-standing policy ingrained in the way the rule has been operated, well, ingrained in the rule. So if the policy of the rule has since its inception been that a person who is compliant with immigration control because he's been granted temporary admission and is then granted leave, even where that is 8 years of having no leave, is then considered to have had leave for the whole period, it is a natural extension of that policy to disregard by taking into account. So if one contrasts the position in this appeal with the position in the example, you have an appellant who came to the UK lawfully, extended leave lawfully, made an error in respect of his IHS payment, but immediately rectified it, had to wait 19 months to eventually get leave through no fault of his own. Should he be penalised because of that error? And in the temporary admission example, you have somebody that turns up without leave, is granted temporary admission, spends 8 years on temporary admission with no leave, no contribution to the economy, probably not working, probably gets leave eventually because of circumstances that have developed in the UK, perhaps a relationship, perhaps a child, and then within 2 years is entitled to ILR. Now, that 8-year example is something that has been in the rules since the long residence provisions came into force, and therefore the construction adopted by the Court of Appeal in Hock is a natural extension of that with respect to overstaying provisions tightly regulated by 39E.
I mean, in that case, isn't it because in the temporary admission example, that is specifically deemed to be continuous lawful residence.
Yes. Yes, I'm not saying that this is specifically deemed, but what I'm saying is that if you adopt that construction, it's not an aberration, it's not an outlier in terms of the way the rule works, it's a natural extension of it. And in any event, once we're accepting that element C goes to 1A, we are qualifying the definition of continuous lawful residence. That's happening in any event. So to say that doing it is impermissible is, in one sense, inconsistent with the fact that you've put element C in 1A in the first place. What one should have done, if one is concerned about changing the definitions, is to say, well, element C should just be ignored, and you still have to make, you still have to satisfy 1A as it is, and the previous disregarding is irrelevant. But if you are disregarding, then in my submission it's consistent with the overall operation of the rule to count.
Can I just ask you very quickly,
Yes.
Going back to 276 B5 and the use of the word disregarded,
Yeah.
I wonder whether in the first limb, so elements A and B, it isn't being used in the sense of ignored. If one looks again, I mean, this is really the point that my Lord Reid was putting to you, at the purpose of the first part of that rule, it reiterates or states that someone must not be in the UK in breach of immigration laws. So that covers any breach, including overstaying, except that where para 39E of these rules applies, any current period of overstaying will be disregarded. So in that context, isn't that really saying doesn't count as breach of immigration laws, i.e. is being ignored for that purpose? Any other breach of immigration laws will count and disqualify you, but we'll ignore that particular subset of that.
Yes.
If one interprets disregard as ignored in that context, I wonder whether it doesn't also mean ignored in the second context, in element C. Because it might be said that it would be a very strong thing to have this rule do what happens in the temporary admission case, where you get a positive deeming, even though you're not lawfully resident, it will be treated as a period of continuous lawful residence. That isn't what seems to be happening in element C here. If one reads it as disregarded, is it not the more, it might be said, the more natural interpretation of that one is ignoring what would otherwise be a break in continuous residence? But that falls short of actually deeming that break positively to be continuous lawful residence, which is what you need for the operation of the rule at its most fundamental level.
I think in Afzal, Sir Patrick Elias said that either construction was rational. I cannot say that it's...
I'm putting to you that one might be more rational than another.
My Lord, my submission would be that if one is comparing the two, bearing in mind the way in which the rule has treated temporary admission and the policy behind that, and then when one goes back to the initial concession where gaps are counted, then the more natural meaning and the meaning that is consistent with the overall history of the rule and the way that it has operated is to count it. That would be my submission. That is the more natural way to look at it. And of course the submission was made in Hock that should also apply to current overstaying, but that is not an issue that is before my Lords. The Court of Appeal was split on that in Hock. Macomb said that is the natural way to read it, and Lord Justice Underhill and Lord Justice Stingerman said that was not. But one could look at it that way as well. But I think that when one looks at it overall, and one has to take into account that the drafting is poor, the history of amendments is poor, the Secretary of State herself has misunderstood the rule and has made conflicting submissions in cases over the years. So it is very difficult to comprehend the provision, and therefore one has to be very cautious before applying too logical a construction to it, because it isn't logically drafted. I think Lord Justice Stingerman said that he didn't think that any thought had been given to it when it was put in. So it is a difficult rule to interpret, and I don't get away from that. But I say that when one looks at everything in context, the clear intention is to count.
Right.
You see, that's not disregarding it. That's actually treating it as something quite significant.
My Lord, can I, perhaps this is...
In the ordinary, I'm looking at the dictionary, OED definition of disregard, to treat as of no importance, to pay no attention to. Well, on your approach, we're not treating it as of no importance. We're not paying no attention to it. We're treating it as actually very important.
My Lord, again, that depends on what you're disregarding. And I say that you disregard the overstaying, the fact of overstaying, so you're treating that as of no importance, and then you just count the period. And that's the reasoning in Hock and Munib Asif. And that's actually the practice that the Secretary of State has adopted, we're told. And if I can take you, my Lord, it might be a convenient
Just
moment.
before, because I think this might be quite important, if I could just ask you to look at the definition again of lawful residence,
Yes.
page 771. I mean, that's a very specific definition. Lawful residence means residence which is continuous residence pursuant to existing leave to enter. Now, in a bookended case, ex hypothesi, you don't have that. So, as it seems to me, you need the last bit of subparagraph 5 to do a very strong thing, to operate in effect as a positive deeming provision to overcome something which doesn't fall within the express definition of lawful residence. Now, and really what I'm questioning is it right for us to interpret 5 as a deeming provision, where we have another example of a deeming provision in relation to temporary admission, where it's an express deeming, against the background of this definition on page 771, might it not be said that the more natural reading of element C is not to treat it as a deeming provision, it doesn't say that it is, but to give it the lesser intermediate effect that the Court of Appeal were disposed to give it?
My submission would be, my Lord, that if one is comparing it with what has been done in relation to temporary admission, again, one has to be careful because of the way in which the rule has been piecemeal adopted. And that drafting history is something that I submit should result in a lot of caution being exercised before interpreting this with too much emphasis on the logic of it. And the explanatory memorandum in my submission is also important. If one looks at the language used in the explanatory memorandum, which is at 667.
So this is, sorry, that's a different reference from a different, but probably different explanatory memorandum. What is the this is the explanatory memorandum for what?
Bringing into force of the version of the rule that we're looking at.
I'm sorry, did you say 667?
Sorry, it's 856.
Oh, that's my fault. 856.
No, 856 is the reference you gave us before. Okay, fine, thanks.
Yes, so right, so this is a document made before Parliament. No, this is...
It's 83, my Lord, I think it's 837. Apologies, it's 837.
So my question then arises, this is what exactly?
This is the explanatory memorandum to the statement of changes that brought in to the rules the current version of subparagraph 5.
Yeah, so this really is the Secretary of State's explanation to Parliament of the changes in the immigration rules.
Yes, and it was consideration of this explanatory memorandum that resulted in the concession before the Court of Appeal in Hock, and it's considered extensively in the judgments, and the relevant
I thought just on Hock, you had told us that the cross-reference, certainly from Lord Justice McComb, to an explanatory memorandum was page 856, but should it have been to 83?
I think it should have been, but I'm just, my Lord, looking at this and wonder if it's the right. I do apologise. Take this. My Lord, apologies. It is not. That's a prior explanatory memorandum that contains nothing of relevance.
Do you want to have a go with 856 or
no,
just
it's
leave it?
877.
Okay.
It's paragraph 57 of the statement of case. And the extract is set out at the statement of case is at 670. Perhaps it might be convenient to just look at the statement of case, which has a link to the explanatory memorandum. 877.
Paragraph 7. So I'm now adrift with reference.
670, my Lord.
Page 670 in the bundle.
670 in the bundle is the appellant statement of case.
Oh, right.
And the extract, the relevant extract from the explanatory memorandum, tells us what the policy intent was.
Which paragraph in your statement of case?
57.
57.
And that is a general explanation.
So it's 896, is that right? Is that the correct?
That's right, my Lord. And I'll refer, my Lords, back to the judgment of Macomb, Lord Justice Macomb, which contrasted the way disregard was being used in another provision for ILR, where it was accepted.
I'm sorry. You gave us a moment ago reference to 877, which is an explanatory memorandum with changes to 276B, and that's the one you refer to in the first sentence of paragraph 57 of your case. But you then go on to 896, which is a different document entirely.
My Lord, I think that is a continuation of the document.
Well, there's a 882 begins a different explanatory memorandum. And this, I think, is where we're going to find.
I think it's the
896.
Yes, I think 877 is the statement of changes, and the explanatory memorandum is then appended to that.
Right.
So it starts at 882.
Yeah. Right. Well,
And then at 749, my Lord, you have which is at 896, 7.49.
okay, just be quite clear again what we're... Yes, so the document that begins at 882 is another one that's actually laid before Parliament. It's not a parliamentary paper, but...
And 882.
Yeah. At the end of the day, what we're interested in is 896, and that's part of a document that seems to begin at 882. And I'm just trying
My
to...
Lord, yes. Yes.
What it is.
And that's, my Lord, the explanatory memorandum to the document that precedes it, which is the statement of changes.
Right.
And I'm not sure that helps us very much, does it?
My Lord, it doesn't help us very much.
I mean, in the sense, that's using disregard, again, in the sense of ignored, isn't it?
It applies across the board. It explains why these amendments are being made. It says that it's for reasons of fairness. Again, that could apply to both constructions, I accept that. But then one contrasts the example that Lord Justice Macomb set out in his judgment of the operation of 245 AAA, which he said, and the court in Masoom Ahmed said, was an example of the disregarded period counting.
And I'm so sorry, just remind us of the paragraph number, we don't need to look it up.
Lord Justice Macomb's judgment, that was at... I think it was, just bear with me a moment.
'85 to 86, is that?
My Lord, yes, 85 to 86.
Yes, right, thank you.
But surely, if anything, that paragraph 749 is contrary to your submission, isn't it? It specifically says disregard any period of overstaying.
Again, my lord, one is looking at language used in a context where the language has not been used very carefully.
Right.
That is exactly the way in which it is phrased in the rule. It's the period of overstaying that's disregarded. But when one breaks the rule down, especially looking at the evolution of the rule, it started with just elements A and B. So the only thing you were disregarding was the fact of overstaying, because the only thing that was relevant was breach of immigration laws. And you have the same terminology, the same use of language added on piecemeal, which makes for unsatisfactory and difficult reading. But when one looks at how the rule has developed over time, it's clear that when one first sees disregard appear, it's about ignoring the fact of overstaying, and then one sees additions to the rule, and we say that you give the same meaning, so you're disregarding the fact of overstaying for the second part of it as well, element C. So element A sets out the requirement in subparagraph 5, you must not be in breach of immigration laws. Element B says disregard any overstaying, so you ignore the overstaying. And then element C says disregard previous periods of overstaying, so you disregard the overstaying again. And the language has also changed, and I've taken my lords through that in the statement of case, so that initially you had a certain form of words which meant you only disregarded the first 28 days, then you disregarded the 28 days and the period up until the decision. Then you have the language change completely when 39E comes in, so that both elements talk about the period of overstaying. And our submission is that one cannot read too much into anything because of the piecemeal way in which all of this has been done. And so one has to step back, look at everything and try and make sense of it as a whole. And that is what the court has done in Hock and in Munib Asif, looking at the practice of the Secretary of State, looking at the policy guidance, looking at the way in which all the elements of the rule work as a whole, and has reached a construction which we say is principled and is correct. In Afzal, the approach taken is, we say, marred by failures and gaps in consideration of the relevant factors that apply. And if I could, just whilst we're discussing this, because it's relevant to it, perhaps we look at another part of the rules and the policy guidance to see how there is clear language used elsewhere in the rules that shows that you don't take the period into account. I've already said that 245 AAA is an example cited by Lord Justice McComb as disregard, meaning that you count the period. If one then turns to 774, you have 276 ADE of the rules, which relates to private life. And my lords will see from subparagraphs 3, 4, 5 and 6 that one is calculating a period of residence and one is discounting any period of imprisonment. And if I could take my lords then to 1779, my lords will see there that that is explained in the policy guidance very clearly. At the bottom of that page, the full paragraph, you should be aware a period of time spent in prison will not break the continuous residence of an applicant applying on the basis of their private life in the UK. Rather, time spent in prison will not be counted towards the period of residence, but time spent before and after that imprisonment can be aggregated to make up the full amount of time. So you've got a different word being used and you've got a clear explanation in the policy guidance, and in the long residence rule, you've got a word being used that is used elsewhere to mean that you count the period, and the policy guidance suggests we would submit, and per the construction in Hock and in Munib Asif, that you count the period. There's certainly nothing with this sort of clarity that says, and it's not a straightforward task for a caseworker to understand that you count up until X date, you stop, and then you start counting again. One would expect clear instructions. The lack of those clear instructions suggests, we submit very strongly, that you count the period.
But, I mean, this is addressing a situation where you do satisfy the definition of lawful residence because you do have the visa clearance to come into the UK. So you need something which stops that period of lawful residence counting.
My Lord, this is not a lawful residence issue. This is the private life rule is just about residence. So if one is relying on the private life rule, typically you will have had gaps in lawful residence. So it's simply about your residence, the continuity of it. But the point is the word, discounting. And if you're using that word to reach that effect...
My point is, you're using that against the backdrop of if you didn't do something, you would have someone that satisfied the usual requirements of 276 ADE.
Yes.
Whereas, so you don't need to do any deeming to make them satisfy those requirements.
My Lord, that sort of analysis in my submission, when one is looking at the rules, as Lord Justice McComb says in his judgment, that are to be applied by people representing themselves as well as lawyers and representatives,
Right.
is such an in-depth analysis that one surely cannot have expected that the Secretary of State would have drafted these rules with those sorts of nuances in mind.
Yes.
And one is searching for what the Secretary of State intended. And in my submission, if one is using the word discount for an effect in the rules in one place, then one would expect that that same word would be used elsewhere. And that is parity of reasoning with Afzal reasoning against us, which is that if you use disregard to do X, then you must use disregard to do Y. But then you must take into account the rules as an overall piece of work. And the guidance as well. Again, the guidance is drafted overall. Caseworkers apply all elements of the guidance. If one sees the guidance for 276 ADE and sees that you have to discount in this way, the caseworker is going to think, when looking at the long residence guidance, that disregarding means something else, and we say that is what the court construed in Hock and Munib Asif, and it's consistent with the Secretary of State's practice and policy.
Mr. Deputy, I see you've got a quarter of an hour left. You also have reply time, which you can eat into if you need to. But I think you need to think very carefully about how to present your remaining two issues economically.
My Lord, yes.
We've got your written arguments,
Yes.
which you would doubtless adopt. But I would suggest that you might move on to those issues, if I may say so, without further delay.
I'm grateful, my Lord. I will leave any further analysis of the Afzal judgment. I think we have discussed large elements of it already.
Yeah.
It is in the written statement, and if I can just very quickly sum up my submissions on the construction, because we have the policy guidance and then we have Iyieke as well. We say that the construction in Hock and the reasoning in Hock and in Munib Asif should be preferred. We would remind the court that in Hock the court was specifically constituted to give guidance on this issue. We would also draw attention to the fact that when the appellant sought permission to appeal in Hock, the Secretary of State filed a notice of objection, which is at 619, and we'd asked the court to take into account paragraphs 9 and 11 of that notice of objection, which doesn't suggest that there was any misunderstanding of the Secretary of State's position, which is relevant to the policy guidance practice issue. And no issue was taken with respect to the construction being wrong. At paragraph 11, it suggests that the interpretation given was in line with the submissions of the Secretary of State, but certainly it is said that it is more lenient and in keeping with the spirit of the immigration system. Likewise, the reported decision of the upper tribunal, which clearly ruled on this issue, was not appealed. And the reasoning in Afzal that the construction in Hock rewrites the meaning of lawful residence must be looked at in the context of the way in which the rules and the policy have always treated temporary admission, because although it is amending the definition, it's not rewriting it, it's a natural extension of it. Moving on to the policy guidance practice issue, the appellant's submission essentially is that if there was a practice of counting these periods of leave, why was that practice not applied to him? And when one looks at the decision letter is entirely absent in terms of addressing this, because the caseworker has clearly misunderstood the rules entirely and misapplied them. Now, if there is a practice, and it's not clear whether there is a practice or a policy, but either way, whether it's a practice or a policy, and one has to look at the concession in Hock very carefully and what the court understood in Hock very carefully, but either way, no explanation has been provided in the refusal as to why that practice or policy was not applied to the appellant. And we say that that must be fatal to the Secretary of State's case, because even if the appellant is wrong on the Section 3C construction and wrong on the 276B construction, the Court of Appeal accepted that he fell within 276b(5) and that the period fell to be disregarded, and therefore it must be the case that at the very least consideration should be given to applying the practice to his case, if the practice is distinct from a policy. And the appellant says that it is unclear and unsatisfactory that it is still unclear what exactly the concession was. The understanding was in Hock, the concession was that the practice was the policy. In Afzal, the court has said that it isn't clear that the practice was the policy. Well, then what was the practice? And it can't have been just a few rogue decisions, because that isn't a practice. For a practice to come to the attention of the Secretary of State to result in it finding its way into a concession before the Court of Appeal, there must have been something significant. And it's never been said that the practice was inconsistent with the policy or inconsistent with the rules. It might have been more generous, but even if it was more generous than the rules, if there is a practice, it's a policy, written or unwritten. And there's no reason given as to why that policy or practice was not applied to the appellant's case. And the Court of Appeal failed to give any consideration to this issue. It was clearly an issue that was before the court because it was one of the grounds of appeal. It wasn't considered at all. It was only, the policy was only considered in the context of the Pochrial issue, whether it was an aid to construction. And my lords, then if I could take my lords to Iyieke, the judgment is at 401. The reasoning begins at paragraph 26, which is 406. My Lords, I think it will be most economical for me to make submissions in relation to that by reference to the written statement of case. The relevant part of the written statement of case for the appellants is at 679. It's a relatively short point, and one doesn't have to develop it too much because the background of the long residence rules and policy has already been considered. And relevant to this appeal, Iyieke's appeal, squarely is the temporary admission issue. Because in Iyieke's case, he had a period of 111 days whereby he had made an application within 39E that had been refused, but after 111 days he was granted temporary admission. And then a period of, I think, in excess of 2 years, tell me exactly what the period was, is covered by the temporary admission, so that when he eventually gets leave, after an application that is refused and then appealed successfully, that entire period counts as lawful residence. And so you have a stark contrast between the operation of 276b5 and the temporary admission rules in one set of facts. And the issue before the court turns on the use of the word the as opposed to a in 276b5. The previous application as opposed to a previous application. And the appellant would again draw attention to the remarks made by the Court of Appeal across the board in Hock about the way in which the rule has been drafted, and would say that in that context it is dangerous to read too much into a single letter, and that the construction reached by the court in Afzal required words to be read into the rule. A plain reading of the rule would mean that a period of overstaying between periods of leave where you've complied with 39E is disregarded. And one can also see the impact of disregarding as ignoring the period as opposed to counting it here, because you disregard 111 days in terms of ignoring it, but the temporary admission period, which is much longer and follows straight afterwards, is counted in its entirety, and we say that that is an absurd result.
What do you say about the illustration given at page 701, paragraph 51, 1 and Roman numerals 1 and 2?
My Lord, in relation to that illustration, you are inevitably going to get situations whereby there are outcomes that one considers illogical or unfair, and we've already considered some of those earlier in my submissions. But one has to understand the Secretary of State's policy. The policy is in relation to making, the overarching policy in overstaying is making applications in a timely manner. And in the example where an application is made out of time, it's made in a timely manner in accordance with the rule. In the other example, after refusal, there is no timely application. That's the rule set up by the Secretary of State, and that's the effect of it. An application that's made a year later would likely fail in both cases unless it was exceptional. because the immigration rules across the board, except for human rights and protection-based claims, contain an overstaying requirement. So 39E would bite, and therefore, unless there was a human rights element or a protection element, the further application a year later would be refused because of the overstay. And that's in either case, whether you've made the previous application within 39E or not. And if, there is no policy, there's no published policy on when the Secretary of State grants immigration bail or temporary admission that I'm aware of. We've asked the Secretary of State, and there hasn't been a response yet, but they haven't had much time to respond. We only asked them last week, to be fair, but we haven't found anything that's published. But it does appear that the timing of a grant of temporary admission or immigration bail is arbitrary. I'm aware of cases where it is granted at the same time as a refusal. So in Iyieke, if he had been granted immigration bail at the same time as his application had been refused, the situation would be very different. It would be the same with Afzal. Had he been granted immigration bail or temporary admission at the time that his application was refused, the entire period would have been counted in any event. Why he wasn't, why either wasn't at that time, is unexplained. But it is part of the backdrop and the context within which one is construing all of these policies and requirements. And whilst you might get anomalous outcomes, it cannot, in my submission, seriously be considered that a person would deliberately not make an application in time and apply within 28 days or 14 days in order to plan for a potential benefit down the right line when he applies for ILR. It's simply not something that somebody that wants to abuse the system would think of. The reality is that it will always be beneficial to make an in-time application because leave is extended by Section 3C. And you can see that from the facts in Hock. Leave was extended in those cases by a number of years because they made in-time applications that then resulted in rights of appeal. And throughout that time, Section 3C leave continued, including a right to work, which is important to any migrant in the UK. So to suggest that this anomalous outcome incentivizes abuse, in my submission, doesn't add up. And in any event, these cases are not cases of abuse, and one ought not to construe the rules on the basis that they could be abused. And I've already said, my lords, that abuse is dealt with within the rule in any event at 276B2 and 3. But, my lords,
yes.
Going back to the case for the appellants, my lord, I think I'm happy to rest there because I have referred to my statement of case. The case in Iyieke is fully set out and is a narrow point.
Yes.
And the other parts have been developed, my lord. And if there is anything, my lords, I'll come back to that in reply, if I may. I'm very grateful.
Thank you very much indeed, Mr. Jafferty. In that case, we'll adjourn for the day and resume at 10:30 tomorrow.